Ilya, great to have you on the show today. I would love to go over several different areas of the law, of constitutional law, of free speech with you here today. And if we could, let's start with number one. Let's start with Twitter. From what you've seen so far in the Twitter files, is there a definitive case to be made? Can we feel confident in the indictment that the United States government colluded with Twitter and probably all other elements of big tech to abridge the First Amendment of the United States Constitution?
Well, what I've seen in the Twitter files, there's stuff about the Biden campaign before he was elected to colluding with Twitter in various ways, which is a political problem. It's also, I think, a violation of Twitter's own policies. So there's a breach of contract, potential fraud, civil liability there, things like that. I don't know if we've gotten to the batches. There's quite a lot there to unpack where it's the administration itself, the government acting in cahoots with Twitter. There's litigation ongoing about that. I'm part of that, the Changizi case that I just filed a brief in and wrote about in City Journal. But that's a separate issue. It's when we're talking about a First Amendment or a constitutional violation, it has to be government collusion, and there has been that. Jen Psaki and Corinne Jean-Pierre have denied it, but the government has been in cahoots with Twitter to censor so-called misinformation about COVID and other things like that. The Twitter files, I think, are before that. I think they're the Biden campaign. They're about Twitter's decision-making about banning Donald Trump and other things that are definitely bad and definitely violate their own terms of service. Don't get me wrong. Twitter's a private company. They can have whatever policy they want. But if they're violating their own policy, that's a breach of contract and potentially makes them liable for fraud as well. It's when they collude with the government, as the administration, that we get into constitutional violations.
Okay, and I think you and I both have some suspicion, as you mentioned, you're already part of a lawsuit that once the Biden administration officially takes power in Washington, D.C., the collusion and censorship doesn't only continue as it did under the campaign of Joe Biden, but I think it's a reasonable assumption that it actually increases and expands to other topic areas like you mentioned when it comes to COVID, January 6th. We can see what will be revealed in future Twitter files. But let's stay with what we know. Let's stay within what has been revealed so far in the Twitter files. It's true, the Democratic National Committee and the Joe Biden campaign would not count as government collusion, for example, in the Hunter Biden laptop suppression. But what about the role of the FBI? What about the role of the DNI? What about the law enforcement apparatus that was clearly in, I think the word they chose to use was a partnership with Twitter?
Absolutely. When the FBI, quote unquote, asks you to do something, that's a problem. It's kind of like it's a nice social media platform you got there. Wouldn't want something to happen to it. In terms of, that's an allusion to how the mafia works, of course. But in terms of the government, it's they have all sorts of regulatory sanction. They have enforcement capability. So there's an implicit threat, even if Twitter is amenable under its former management to do the government's bidding or to be in cahoots in various ways. But that's really what needs to be established, that there's an implied threat, collaboration, doing something at the behest of, acting as an agent of the government or under threat of some sort of government action.
Okay, I want to go into that in just one moment, but let's now for a moment play devil's advocate or attempt to embody the defense of the FBI. What would be your response to the argument that we often talk with private enterprises and offer them advice? We often will somehow coordinate with the New York Times. Certainly the CIA would have a relationship with the New York Times about the appropriate timing of the release of a story. The New York Times or any other publication might call us to check the veracity of something that a source has told them before they report it. So we have an ongoing dialogue with all sorts of members of the media, and it's perfectly fine for us, the FBI or the office of the DHS or the Office of Intelligence, what is it, the DNI, to coordinate and offer advice on what is or is not disinformation. It's not some skirting of the First Amendment for us to offer various media institutions our perspective. What do you say to that argument?
There certainly can be gray areas and fuzzy lines. It's not that the government is prohibited, FBI or any other agency prohibited from talking with private enterprise. And certainly if a media organization asks the government as a fact check to corroborate something, that's not, the government telling it what to do for sure. But that's why we need discovery. That's why a lot of these suits that have been brought have been dismissed before there can be depositions or a document produced, even if under seal, even if they can't be made public. But that's what needs to be investigated in the course of normal litigation. So, I mean, there's at a certain point, it becomes a jury question. Would a reasonable observer feel cajoled or coerced by something that the government is asking, or is it simply just information exchange? Or to put it another way, would a reasonable person feel comfortable saying, no, I don't want to talk to you about this? Or is there really a threat of pressure? That can be in the eye of the beholder, to be sure. But the law, it could be clarified. That's why I hope this ultimately could and likely will, some aspect of all of this will end up in the Supreme Court to clarify for the digital age in the context of media platforms what exactly crosses the line between simple information exchange and collusion, collaboration, implied coercion.
Okay, so let's start then to connect those dots on what would be necessary to make that case. So first of all, do you think it's necessary that at some point we see an email or some sort of trail, paper trail, digital trail, where there is a government agent telling Twitter this story should be censored? And I don't know the language. Maybe you can help us flesh out that language of what would be considered, therefore, a step too far. Right now, we don't have that proverbial smoking gun, Ilya, and I've made the analogy several times. Well, you don't always have a smoking gun in a murder trial. You can make a murder case with circumstantial evidence. And we have the FBI meeting on a weekly basis with Twitter. We have the knowledge that a case, story was suppressed. We have motive. We have explanation after the fact of essentially the murder plans and saying all these intelligence agents saying it was Russian disinformation. What we don't have is that email, is that phone call, is that digital evidence that a government agent said you should censor this. Is that necessary?
Well, the strongest case would be, if you had an email saying, censor this information or we're going to go after you, literally stop the press.
Hold on. Can I just stop you right there? I want to address the or separately because I think that's important as you describe, right? The or is a second step in the, let's call it the conviction of the United States of America. But at first, before we get to the or, meaning that inducement, do you need that smoking gun to establish that the government played a direct role in the censorship? Or can you just make the case with the circumstantial evidence?
Well, it depends what you mean by smoking gun. If you're talking a civil rights lawsuit, the deprivation of your civil rights, which means censorship, First Amendment, under a statute called Section 1983, 42 U.S. Code 1983. That's a civil lawsuit, so the standard is a preponderance of the evidence. This is not beyond a reasonable doubt, as in criminal cases. This is a civil lawsuit. You have to get over the issue of sovereign immunity. There's certain other kind of jurisprudential technical hoops to jump through. But assuming, the lawyers figure that out, it's just a preponderance of the evidence, meaning more likely than not. And so definitely you don't have to have a smoking gun. You have to have, ultimately you have to convince a jury that it's more likely than not that the government violated someone's civil rights by censoring them or otherwise.
Okay, and I'm going to follow up there because I find this stuff fascinating, and I hope everybody watching or listening does as well. Sovereign immunity is the legal principle that the United States or any government or any state actor has liability protection. You can't sue, but you can, as you point out in certain instances. How do you get around sovereign immunity?
Often the government allows you to sue itself in various ways. So if you feel that the government owes you something on a contract, you're you pave roads or you provide missiles, whatever the case might be, government contracts in lots of different ways, and you feel that the government didn't pay you what they owe. You can sue them, absolutely. Not in the normal way that you would sue under a normal private contract, but there are various federal statutes that allow you to do that. And so similarly for deprivation of civil rights, there is this Section 1983 of the U.S. Code that allows you to do that. Now, if you're going after individual officials, then there are further complications there. But if it's just trying to hold the government as an entity or some agency liable, then you don't need to go into individual immunity. It's just that particular part of the federal code.
And then give me an example of how this actually becomes an action. Someone that we know had their voice censored. We could take, for example, Dan Bongino was listed as somebody whose account was suppressed. So, for example, Dan Bongino sues Twitter and the United States government for the statute that you have mentioned several times now. And I would assume he's got standing, therefore. We know that he has standing, has the ability to file a suit because he was an injured party. Does he have to show some semblance of damages as well? Like, I was hurt in this quantifiable way?
For civil rights suits, you can even have nominal damages, meaning, if you were harmed even $1, or there can be punitive damages on top of that. In certain circumstances, depending on the type of action, there are statutory damages provided regardless of what the actual damages might be. You mentioned suing both Twitter and the government. Well, you can have different kinds of claims against those entities. Against Twitter, what we've been talking around is a concept called state action. That is, only a government actor can violate the First Amendment. I don't owe you any constitutional rights. You can't sue me for a violation of your constitutional rights. You can sue me for tort damages if I punch you or breach a contract, things like that. Similarly, Twitter. Now, if Twitter acts as an agent of the government, then it's the government, in effect, that you're suing for the constitutional damage, but then Twitter gets thrown in for related civil damages as well. But yes, Dan or anyone else who was shadow banned or completely banned, just thrown off the website altogether, maybe there's a potential for a class action for everybody that pursuant to this policy and practice that turns out to be illegal or in violation of Twitter's own policies. Maybe there could be a class in that regard that would sue, you could have a trial eventually. You could have a settlement before trial, but a lot of these cases that are currently existing are trying to make the connection between Twitter's censorship of so-called misinformation and the government requesting it to do that, kind of sitting on the same boards and being in regular email contact saying, what do you have for me today? Who else do you think I should downgrade or what the case may be? Right. That certainly looks like not completely kosher.
Okay, so now we've established that someone like Dan Bongino or a class action of several individuals who've had their speech suppressed would have standing to bring a lawsuit. They could bring lawsuit as a civil rights action, as you mentioned, with only nominal damages, and that you would only need a preponderance of the evidence to convince a jury that there was this partnership. Although there may not be a smoking gun, there's this partnership between government and a private enterprise, Twitter, to suppress speech. But then I want to get to the second part of this legal equation. Again, now this would be addressing the FBI's argument. We can give advice to whoever we want. The question is it advice or is it inducement? Is it a threat? And that's where you went with the or. And I'm curious now, what would amount to nice little business you got there? It'd be a shame if something happened to it. We know there are regulators on Capitol Hill, Democratic politicians talking about potential regulation. We have, by the way, as you described a minute ago, we have executives going back and forth all throughout big tech, into government, from government, back into big tech. So what would be evidence in your mind of sufficient inducement or sufficient threat?
Well, the law is a little murky in this area, and that's why I think these types of cases are going to have legs, because there's actual new law to be broken, not just factual development about whether there was a smoking gun or to what extent there was coercion. In the sense that if it's mere collaboration, if there's no threat at all, Twitter does not fear government action. The government has no intention of regulating further. It's just, Twitter wants to be helpful. Whether for ideological or business or other reasons, Twitter decides, we want to get rid of this type of information. The government knows best how to go about doing that. So just because our goals are aligned and just because we're thinking the same way, that does not make it state action. And, there's plenty of cases that say, merely acting in a way that benefits the government or that the government would want, that's not enough. There has to be some sort of, whether carrot or stick, whether, acting in a way that you wouldn't otherwise, that has to be established, I think. But it's not clear in the digital space, and especially in the censorship space. Typically, these sorts of cases involve other types of claims, not First Amendment, not speech, but actually the government inducing or claims of inducement or threat to do something, and effectively the private party becomes an agent of the government in that regard. So here again, in the brief that I filed in this one case that's now on appeal. There is a legal question about what is this just the motives are aligned, the goals are aligned, or is there an actual inducement, whether carrot or stick here? But we haven't been able to establish that because this particular case and certain others have been dismissed at the motion to dismiss stage, meaning there has not been the plaintiffs have not been able to even look at documents or get depositions of key witnesses.
Because that would be a question for a jury. That would also be I assume, a preponderance of the evidence question for a jury on whether or not there was sufficient coercion between the government and Twitter.
Eventually. So first, it goes to a jury if there are any purely factual questions to determine. If it's just questions of law, then judges grant what's called summary judgment, which you've probably heard of. That means that there are no material facts in dispute. And based on the agreed upon facts here, the judge says this is or is not a violation of the law. It goes to a jury or a judge as fact finder. Not all cases go to juries. You can sometimes work out that the judge is the fact finder if there are facts in dispute. And most cases eventually settle. When it starts looking not so good for one side, if indeed it's not, if it doesn't remain murky, if it's not just a judgment call about what the reasonable observer would decide, then those sorts of things end up settling.
And so, for example, you have the case that you are currently participating in, and then we have this theoretical case that you and I are also discussing here. What, in your mind, Ilya, would be compelling evidence of coercion from the United States government? I just gave you some examples of, we could easily come up with Democratic politicians saying it's time to regulate big tech because it does not censor sufficiently. So, what would be, and again, that's why I asked, is this a question for a jury, but what in your mind would be compelling evidence showing that, hey, you better censor or we're going to break you?
That's actually a legal question.
Really?
What sort of things would need to be shown? And it's a standard that would need to be established by a higher court. What you're talking about is a phenomenon called jawboning. It's kind of a funny word, but it means, the government, different government officials talking about, we need to regulate, or if they don't do this, we'll do that. It could be one senator, right? One senator obviously doesn't have the power by him or herself to do that, but still, it's more threatening than if you or I went out and said it. And so how much jawboning becomes a threat? I don't know. The law is not fully clear. The cases really haven't been updated for the digital age. So it's one area where I think it would be good for, and I think likely to happen, that the Supreme Court steps in. And at that point, once they establish that standard, whether it's, a reasonable person has to consider that, that kind of statement from a high enough official or something like that constitutes an implied threat. Just
Right.
last week or the week before, the White House press secretary, Karine Jean-Pierre, said in response to a question, we're taking a close look at what Elon Musk is doing. Now, there's an
Right.
implied threat there. When the
Right.
White House says, we are taking a close look at what you are doing, that means, there is that implied I think quite clearly that, if we don't like what you're doing, we are going to, use the full force of the U.S. government to go after you, whether it's through the FTC regulation, whether it's new legislation, what have you. So even an innocuous thing like, it doesn't have to be do this or you'll be regulated or do a specific thing. They're just saying, we're taking a close look at that. That in that context, when it's the presidential press secretary, that's a big deal.
I would think so. And now I understand what you mean by a legal question. We don't yet know the standard. And so the standard would be set by a Supreme Court decision. And you gave us an example of a potential standard, right? Did I hear you right? And that standard would be,
yes.
Would a reasonable person feel under coercion by a government official if you heard what Karine Jean-Pierre said, and then you also heard from an FBI agent, we think this is disinformation and you should probably nuke it. Would a reasonable person connect those dots and therefore be acting under inducement? Did I characterize that correctly?
Right. Yes. Well,
Okay.
See, what you set out, it would be what a legal standard would be, and it would go to the jury to say, well, given the facts of this case, does it meet that standard of, would I feel threatened in that circumstance?
Correct. Okay. Last question on this when we dealing with it from, I think, a civil rights action, to your point. So what's the potential remedy? So either in your case or in our theoretical Dan Bongino or class action suit, what is, I think there's a lot of Americans looking to this and having this discussion, Ilya, about abridgment of the First Amendment, thinking on the back end there's some accountability. So, and probably people aren't very interested in, when I say remedy, the monetary damages of Dan Bongino or a class action lawsuit. Like, what is the real remedy and accountability for those, again, presuming that it worked in the favor of those who were censored? What would be the outcome?
You would probably have an injunction or a consent decree. An injunction is about current action to stop any current action that the government might be doing, or a command to do something potentially. And a consent decree would be looking forward. That is not just in the context of COVID misinformation, so-called, but going forward, the government is prohibited from acting in a way that chills speech in certain ways. However, that would be crafted by the court or the settlement. And it's hard to look prospectively, but the idea is under First Amendment law, the government cannot be an evaluator of what's true and false information. This has come up to the Supreme Court in the context of laws that have existed in about a dozen states criminalizing so-called false speech in political campaigns. And what is false speech? It's whatever a state board, state truth ministry determines it to be. And the Supreme Court threw that out unanimously or near unanimously, not even a close call. So you cannot have a ministry of truth or a ministry of disinformation in that context. How that is phrased in terms of the remedy, there's a lot of wiggle room there, and it depends on the specifics of what exactly the government is nailed for doing.
It almost seems to me, Ilya, impossible to find any bright line. So just to put a button on this part of the conversation, just recently, former President Donald Trump has put together some type of platform. I don't know if you've seen this yet, Ilya Shapiro, to address free speech. And it's sort of a 6-point platform. It's not fully fleshed out, but it does say something in there as one of the, and I don't know if it's 6 actually, how many points. I believe it was 6, but one of them was there will be no, something to the effect of there will be no coordination between the United States government and big tech on what is appropriate speech or something to that effect. And I got to thinking about that. And as much as I like it, Ilya, I also think like the scenario I gave you earlier, the defense of the FBI, where they say, look, we talk to everybody and we give advice. You can't really quash that either, right? Because that's a two-way street. And people will approach the government about the veracity of what they're saying, right? Is this correct? We're reporting this. Is this correct? And you can't have the FBI going, I really can't talk to you about that. I just don't know a workable solution, whether or not it's Donald Trump's or this consent decree.
Well, in kind of the pre-digital age, we know what censorship is. It's the government, at least direct censorship by the government. It's an official saying stop the presses, or you can't publish that, or we're throwing you in jail for publishing that. That happened under Woodrow Wilson, for example. In the digital world, you could write a rule saying you're not going to tell platforms to what they can and can't publish, but part of this, a large part of this, and possibly even more than the government action, is holding the private corporations to account for being transparent. That is, you can have a policy that says we reserve the right to, do whatever we want under no standard, just based on what our CEO wants to do. Or you could have a policy that says we will only follow the First Amendment, or the First Amendment plus these other things that we want to control. But that has to be clear, and the onus is on those companies to follow, even before we get into questions of whether they should be regulated by the federal government or turned into considered to be a common carrier like a railroad or the phone, the old phone network, Ma Bell and all that. Even before we consider government action to regulate tech platforms, they should be held to their own to account for their own policies, and that's, I think, where Twitter, forgetting what the Biden administration is doing, that's a separate issue. But Twitter itself, I think, what the Twitter files have shown isn't even following its own rules, and I think that can ultimately be even more damaging to them. Again, setting aside what's damaging to the government, than the collusion with the government.
Perfect transition. That's where I wanted to go next with you on Twitter. And that is the civil action of a censored individual, not now against the government of the United States. No need to show inducement, no need to show partnership, but simply suing Twitter. And you and I have had a past conversation on Fox and Friends, but suing Twitter for failing to live up to its terms of service. So a breach of contract action?
Yeah. If Twitter, Twitter's had these various policies, and then the Twitter files have revealed that they don't follow them. They're basically, it's like the old bitter joke under the Soviet Union about finding the criminal first, whoever you want to prosecute, and then designing a crime to pin on him. And
right.
So similarly here, they identified certain tweets or certain individuals that they wanted to downgrade, and then they figured out creatively how that retroactively violated some nebulous aspect of their policies, and that clearly is not kosher.
Ilya, it strikes me that if that, it's an interesting situation in the real world where we are now, that and you may be right, that's the potential check on speech suppression, as much as it is trying to make this case against the United States, hold Twitter accountable for its own suppression. And that would be a civil action, as you just described, and that would be about monetary threat. Like, the reason a private actor would not live up to its own contract is the threat of money damages, right? That you'd have to pay someone, which again would require, in our scenario, our continued hypothetical, Dan Bongino to show damages. He'd have to show how it hurt him to get damages from Twitter, I would think. But also, let me just throw this at you at the same time as you answer that.
Just to be clear, even though I'm a lawyer, none of what I'm saying should be taken to be legal advice for Dan Bongino.
I got it. That's very good. Very good. Thank you. You could tell me, and by the way, I echo that when it comes to me as well. By the way, I'm an attorney, and none of this is legal advice for anyone listening. But Ilya, to that point, I think that for it to mean something, like really force Twitter to behave better, they'd have to be afraid of losing a lawsuit and therefore losing money. And I'm not sure that someone could show damages.
Well, you would have to, someone like Dan actually would be a good plaintiff for that, because that would be lost visibility. He has various, media and other projects. Maybe he's losing revenue stream because of lost visibility.
Yeah.
Who knows what any particular plaintiff could come up with. And if we're talking about a class action, meaning all people, a class action, of course, is not just, a lot of individuals. It's it's named, it's representatives of the class, but then it's all people who have been downgraded, shadow banned, censored
right.
in whatever way. That adds up very quickly.
Yeah, and as I sit here and think about it, I mean, I guess it's because I don't think of Twitter as much of a monetizable platform. It's not as compared to other big tech platforms,
Sure.
but like you would easily be able to show damages on YouTube where advertisements roll all the time. And if you had your account turned down, you could quantify how much money you lost, right? But you could probably make a similar case in some way with Twitter. Last note on this. Wouldn't it be awkward in this real world situation that Elon Musk now owns Twitter? So if you sue, you're not actually recovering damages or changing the behavior of the past administration. You're doing it now against the new administration that has a totally different policy.
Well, maybe this is why he initially wanted to get out of the purchase agreement, because he started to understand, among other things, that there were these liabilities out there. But when you buy a company, you assume it's liabilities, and that is supposed to go into the pricing of the transaction. And so, absolutely, this whatever is now recovered against Twitter as a corporate entity. I mean, there could be a direct personal claims against the former CEO and the head censor and all these other people that have come out. But that's a separate issue. Against the corporate entity, absolutely, this becomes the current entity that has to pay that.
Wow. Complicated real world situations. But ultimately, I think while we talk about it,
you're
from a cultural
straining at my
perspective-
ability to talk about. You're straining at my ability to talk about, practical litigation. As a simple constitutional lawyer, I'm typically charged with highfalutin things about what is and isn't unconstitutional, and I find most things unconstitutional when the government does it.
Well, look, I'm familiar with your work as a constitutional attorney, and I appreciate what you do. It oftentimes it's odd as I ask you these questions. It has to reach real world implications, and I think it does in one of two ways: constitutional law, either through a legal action, and that's why I wanted to walk through some of those particulars with you, or just it becomes a cultural reality that we have to wrap our arms around. And I think both are of import when it comes to this conversation around Twitter. All right, I'd love to move to topic number 2, and that is Sam Bankman-Fried. He has been arrested. He has many different counts now, I believe, both. I also believe civil and criminal charges looking like they're headed his way. And his arrest is odd, Ilya, to me, in that the timing of the arrest was the exact day he was scheduled to appear before Congress. What do you make of SBF, FTX, and the charges and the arrest that we now know were executed?
Well, it seems like he's a digital age Bernie Madoff. There's some sort of Ponzi scheme, or just taking money from people. The crypto thing is a red herring. It didn't seem like this impugns cryptocurrency per se. That was just part of how he operated financially, and it's more just taking people, getting these investments, and not having any sort of controls, and using this money willy nilly. There's a bunch of fraud there. It looks like. Who knows what? Just kind of an off the rails operation, and trying to get even more, not just pre-digital, but medieval. It's kind of like purchasing indulgences by spending all this money on left-wing progressive causes, who then would look the other way when it turns out that he's actually worse than a robber baron. So a lot of weird stuff going on there. He seems like he personally looks and seems like a weird dude, and who knows? We'll get to the bottom of that. Of course, he's a privileged kid of 2 Stanford law professors, so I don't know exactly what's. I don't want to psychoanalyze him too much, but I think he's definitely gotten too deep into whatever scheme he was hatching.
No, I think the more interesting psychoanalysis for me is how this individual is capable of duping such a large and sophisticated, not universally, but he definitely drew in sophisticated investors. And the psychoanalysis of how that's possible, FOMO or corruption itself within his partners, I think is absolutely fascinating. But it seems like a story, Ilya, that's bigger. I guess that's the point. It does seem like a story that's bigger than SBF. It seems like a story that needs to be investigated in terms of, as you mentioned, the connection to Democratic politicians, and so many more angles. And do you share my concern that his arrest actually got in the way of answering how big this story is beyond simply the culpability of SBF?
Well, the hearing he was supposed to testify in front of was chaired by Maxine Waters. I'm not sure how how deep of an answer we would have gotten from that hearing itself. You'd have to have further subpoenas and further follow-on actions. And in fact, a legal process now that he's being prosecuted could reveal more than what increasingly congressional hearings are just kabuki theater. So I'm not concerned about him missing the congressional hearing. But I think given that, who knows? He hasn't been following his lawyer's advice so far. He's been giving interviews willy-nilly. There was that text exchange with a Vox reporter, just bizarre stuff. Like, I'm sure if he was under advice of counsel, the counsel was just slamming his head against the desk constantly by his behavior. So now we might not find out right away because there's going to be this criminal investigation, but in the end we probably will know. And I think this is just a Bernie Madoff style Ponzi or other kind of scheme that while the going was good, some of the profits went out to progressive causes, but again, they were kind of like indulgences, buying people's goodwill or having people look the other way. And now the house of cards has collapsed.
They have collapsed. And then the last question on this will be, did those indulgences pay off? They don't seem to be paying off at the moment. Democratic politicians do seem to be going after SBF, and I don't know how you would avoid it at this point. But what happened up to this point to keep attention from being focused or to keep the train running would be a curious investigation. I mean, you don't
the
pay
media
people
coverage is
for
definitely
nothing. So what was the something?
Yeah. The media coverage is definitely different than it would be in other circumstances. I mean, after all of this scandal broke, before his arrest, and then about a week and a half or 2 weeks ago, he did a panel hosted by the New York Times.
Yes.
He's still been invited as, it was kind of poo-pooed, like, he has some sort of like scandal, little cloud over him, but still look at all the good that he's done and all this, treated as a polite member of society and what have you. So I think there's still, by purveyors of elite opinion, they're still unsure of how exactly to deal with this. And look, a lot of these people that got his largesse, whether activist groups or nonprofits or media organizations, it's not like they're complicit in his fraud or whatever other nefarious dealings he was involved in. They just got the profits, and it could show that they're being willfully naive.
All right. Number 3, Ilya, I don't know if you remember, but you and I have met before beyond just through the television lens of Fox and Friends. Well over a decade ago, when I used to work at The Blaze, I was on a show called Real News, and you came in and you were on that show from time to time. So I kept up with your work and kept up with you, and then I certainly knew who you were. When this summer, I don't know that you're the last victim of cancel culture, but you might be amidst the last wave of cancel culture, or so we could hope. You, I guess, in effect, were canceled this last summer, although you were reinstated and then you resigned, and which you can tell us about, for the following tweet. And I want to read it, and I would love for you to tell me both what you meant, how it was interpreted, and what happened at Georgetown. You tweeted the following, and I believe it's in the wake of Ketanji Brown Jackson's nomination to the Supreme Court. And
it was before that.
It was before that, but Joe Biden had already said
it was when
he had already said that he would be nominating
the
a
news,
black woman.
The news of Justice Breyer's retirement had leaked, and Biden reiterated his campaign pledge to appoint a black woman
to the Supreme Court of the United States. And you tweeted the following: objectively, best pick for Biden is Sri Srinivasan, who is solidly progressive and very smart. Even has identity politics benefit of being the first Asian, parentheses, Indian American. But alas, it doesn't fit into the latest intersectionality hierarchy, so we'll get lesser black woman. Thank heaven for small favors. And that's the tweet that is, in effect, gathered or drew the crosshairs of cancel culture. But just, I think, as a point of clarification, then you tweeted secondarily, because Biden said he's only considered black women for the Supreme Court, his nominee will always have an asterisk attached, fitting that the court takes up affirmative action next term. Tell us what you meant and tell us how it was interpreted.
Right. So this was, and the reason why this all blew up was I had been at the Cato Institute for nearly 15 years, the libertarian think tank, and I had gotten a job at Georgetown at the law school to be executive director of their Center for the Constitution, which is an important center because, as we've learned, the rest of the law school is a center against the Constitution. But in any event, a few days before I was due to start there, I was on the road. If I had been at home, this wouldn't have happened because I wouldn't have been scrolling through Twitter late at night. I'd be in bed with my wife and reading or what have you. But I was in my hotel room, end of January, still steaming at this news of Breyer's retirement and what was going to go on. And I'd written a book, Supreme Disorder, about the politics of judicial nominations. I mean, this is right in my wheelhouse. And I thought, this is just preposterous. He's ignoring all these great candidates. I thought if I was a Democratic president, if I wanted to advance progressive jurisprudence, who would I pick? Oh, Judge Srinivasan. I still to this day think that's the best guy on the Democratic appointed bench. I later apologized to Judge Srinivasan for dragging him into all of this stuff. But that's what I tweeted. And all hell broke loose overnight. I went to bed, and my ideological enemies picked up my tweet, and it blew up. The next morning, I woke up, I looked at my phone, I'm like, oh, this was mischaracterized. This was willfully misinterpreted. What I meant was clearly that if I determined that this one individual was the best pick, then everyone else in the entire universe was less qualified, or given the limitations of Twitter's characters, lesser. And in this case, it was a lesser black woman, a less qualified black woman, less qualified than this person who I said. And away we went. It was a very standard argument against identity politics and the use of race and disqualifying people based on race and sex, and an opinion that 76% of the American people shared, according to a poll by that right-wing rag ABC News. But nevertheless, Georgetown suspended me with pay. I was basically paid for 4 months. It took them to investigate this tweet, 4 months to investigate whether I had violated harassment or anti-discrimination policies. At the end of this, I'm sure they spent like $1 million on outside counsel. They hired Wilmer Hale, one of the most expensive D.C. law firms. And somebody looked at a calendar and realized I hadn't been an employee when I tweeted, and so wasn't even subject to these policies. So I celebrated that technical win, but then when I looked at the fine print, this report I later got from the diversity office, it made clear that were I to say something like that in the future, then discipline would follow. And I simply could not do the job I was hired to do, comment in the media about affirmative action cases like the one at the Supreme Court, or abortion, or any of these sensitive issues without facing this sword of Damocles. And so that's why I quit and made what we lawyers call a loud exit, shining the light on the rot at the heart of legal academia generally, and Georgetown specifically. And all this is written up. I've gone into some detail on my Substack, Shapiro's Gavel.
Ilya, and look, for any of us that live in the public eye to some extent, you understand, you learn that once you're explaining, you're losing. But you used a term which I totally understand, which is, I believe, on numerous occasions, for example, I have been willfully misunderstood. That I don't think it's not like I can't be bad at communication. I certainly can communicate poorly. But there's a willingness out there to interpret what you have to say in the worst possible light. So I guess the phrase lesser black woman is where the target ended up focusing. And I guess I want to, just because I find it personally interesting, I guess logically it went like this, right? So you weren't making the argument that all black women are lesser, but that if you have committed yourself to a standard of only picking a black woman, you have made it necessary, unless there is a black woman, and now we're talking about an individual scale, right, who in your mind is at the level of the height, which in your mind was Srinivasan, and so therefore logically you have committed yourself to a standard of lesser because you put as a priority not merit, but skin color. Is that fair as to the logic of what you had to say? But it was interpreted, willfully perhaps, misinterpreted as, oh, Ilya Shapiro thinks all black women are lesser.
Absolutely. That's exactly right. Or as Dean Traynor put it, that no black woman is qualified to be on the Supreme Court. I think we were talking about the reasonable man standard or the reasonable person standard. I don't think it's reasonable to interpret my tweet to say, no black woman is qualified, or all black women are, I don't know, lesser as human beings, or something like that. Look, it's not the best phrasing. I apologize. I issued a limited, in cancel culture, the advice is never apologize. I mean, look, right. I like you, I communicate for a living in various ways, and that was a failure of communication. Not because I'm racist or the mask slipped or any of this BS, but because it was inartful phrasing. When I write an op-ed, when I write a law review article, when I write a brief, and I think about things for a long time, or any amount of time, I mean, you phrase it the way it should be phrased. This is a tweet that I spent half a second thinking about, and yeah, it came out poorly. So doesn't excuse what the mob that went after me did, or how they twisted my words and how they painted me and all that. But that's exactly what happened. But it shows the loss of grace in this world. One thing I learned, part of cancel culture, and seeing your ideological or political opponents not simply as wrong, but necessarily evil. And since politics has replaced religion to a large extent in our society as America has secularized, if something that your political opponent says is wrong, then that's heresy, and it's not worth hearing. I mean, it's an unhealthy dynamic, I think, in our society writ large, and it's magnified in the context of higher education. I think that's why I found myself in this situation. If I had just been at Cato, or now as I am at the Manhattan Institute, and I'd tweeted this, whatever, it wouldn't have been a story. But since I was trying to enter an institution controlled by the left, namely an elite law school, that could not be, and so my enemies seized on that and tried to boot me out.
All right, last question on the mechanics of cancel culture. It's always been my belief that at some point the mob's irrationality runs into the reasonableness of an individual who's capable of thinking for themselves, and you're hoping that person sits in a position of leadership. But what I've found, I believe, Ilya, over the last, let's call it 3 years now, is that reasonableness isn't what you can hope for in leadership. You have to find strength. So in other words, there are people in every big corporation canceling others even when they know better because they are afraid. So at some point, and this is now I'm just guessing, but at some point somebody within Georgetown goes, that's not really what Ilya meant, and I can see how he meant it this way. But that person almost inevitably, instead of showing irrationality, showed weakness, and they gave in to pressure. And I'm just curious, in your mind, where do you think that pressure would have come from? It can come from anywhere. Employees, colleagues, students, online mobs. What wielded the most pressure internally for you at Georgetown?
Well, look, Bill Traynor, the dean of Georgetown Law, is not a woke radical. Most of these deans or other higher education leaders are not woke radicals. They're spineless cowards. They're bureaucrats. Yes. And the problem is, what's different now from when you and I were in college or law school isn't the ideological ratio either among the student body or among the faculty. I think that's pretty much unchanged. What's different is you have this greater bureaucracy, and within that, especially these DEI offices, diversity, equity, and inclusion, which are Orwellian terms that actually preclude intellectual diversity, prevent equal opportunity, and exclude anyone that transgresses from progressive orthodoxy. And that's really, they're a power unto themselves. Even the dean of an elite law school cannot cross that kind of institution, which sure is propped up by students and by certain other types of stakeholders. And so Dean Traynor here, with the advice of the $1 million law firm, decided, well, we'll try to have this middle course. We'll say we can't do anything to Ilya because he wasn't an employee. We won't take a judgment one way or another. We'll say we're for free speech, but we're also against discrimination. These two values are in conflict, and it's tough. Luckily, we don't have to take a position here. Well, that kind of weaselly thing will not fly. I don't think Dean Traynor did himself or Georgetown any favors in doing what he did. Heather Gerken at Yale finds herself in similar hot water. Judges are boycotting hiring Yale for their clerks and things like this. Higher education, generally law schools in particular, it's worrying because, of course, these are our next generation of legal and political leaders in law schools, are in real crisis. And I'm optimistic about society writ large. I've seen pushback. I think the pendulum swinging back. We saw over this summer Netflix telling some of its young staffers, look, if you don't like what Dave Chappelle is doing or some of our other programming, maybe you should look for other employment. In civil society in different places, there I think I see green shoots. Higher education is one place where I'm pessimistic, even though it should be easier there than anywhere else to affect change. These deans, the university presidents and provosts are good at instilling cultures, whether that's public service, whether that's inclusion and diversity, whatever they want, they can do that. They can similarly do that for free speech and civil discourse, and they've chosen not to. So we'll see what happens. Again, I'm not optimistic about law schools, but I refuse to be canceled. And once my lawyer took the reins off, and we saw that this was a cynical ploy to not take a decision until students were off campus, and then have this weaselly thing come out. I didn't seek out to become a poster boy for cancel culture. Sure, I covered free speech as a constitutional lawyer, but I'm using this platform to expose this rot and trying to do my part in showing what's going on and giving people strength. Not everybody has the platform or can write in the Wall Street Journal. When I ran into hot water, has friends like Barry Weiss and others that go to bat, and I learned who my friends were certainly during this ordeal. But there's strength in numbers, and there's power in saying that the emperor has no clothes, and getting together and in as Alexander Solzhenitsyn said, live not by lies.
Wow. Inspirational. I'm glad you shared that story with us. And I appreciate your legal perspective, even if it went beyond the realms of constitutional law today on all of these different stories. I really appreciate your time. Thank you, Ilya Shapiro.
My pleasure, Will. And I must say, I know that I think I recall when we met when you were at Blaze. But another thing we have in common is that when I was in high school, I played water polo a fair bit, and I know that you were a collegiate water polo star. So, yeah.
What state was that?
Great sport. This was in Ontario, Canada.
Really? Okay.
So we found water that wasn't frozen to play on, and we were pretty good. We beat most of the East Coast teams. It's when we ran into you Californians that we got into trouble.
Well, I'm not a Californian. I will never say that. I'm a Texan and always will be. But you're exactly right. The powerhouse of water polo in the Western Hemisphere resides. And is that fair? In the Western Hemisphere, Brazil's pretty good. So in Central America and North America, the power of water polo resides in California. So I didn't know we shared that in common. I'm glad to know it. Thank you, Ilya. Hey, it's Will Cain. Click here to subscribe to the Fox News channel on YouTube. It's the best way to get our latest interviews and highlights. And click to subscribe to the Will Cain Podcast for full episodes right now.